Hello, everyone. I know that there are folks still coming in. My name is Venu Gupta. I am the new permanent director of the Chicago Lawyers Committee for Civil Rights. I was the interim for about 6 months, and I couldn't be more thrilled to be working with this team on the issues of defending and protecting civil rights at this moment. We are thrilled that you are all joining us. Um, as part of our goal to protect and defend civil rights, we are launching a $50,000 match campaign. So I'm flagging this for everybody who's here now because I know folks tend to jump off. Every dollar that you provide will be doubled. So $2, $4, $5, $10, $500, $1,000. No gift is too big or too small, and it will all go to defending what has been the biggest assault on civil rights since the Jim Crow era. So we'll put that link in the chat. Please consider making a contribution. You are all lucky to be here for our first organizational virtual conversation with Professor Jody Freeman. Um, Professor Freeman is the Archibald Cox Professor of Law at Harvard Law School, one of the nation's leading scholars of administrative and environmental law, and founder of Harvard's Environmental and Energy Law program. She served as counselor for energy and climate change in the Obama White House, and Professor Freeman has written extensively about structural deregulation. In fact, I think she and a co-author introduced this framework, which is a framework for how to understand how presidents can systematically undermine agencies' core capacities. And this concept has become central to understanding current threats to the administrative state. And we are going to get into that. Um, and before I hand it over to Professor Freeman, I just want to say thanks to all of the Chicago Lawyers Committee staff who helped to make this happen. If you could all just raise your hands. We're very lucky to be part of, to have these folks on our team. And I would love to see people on camera. I know that it's really easy to turn your camera off, but we're talking about heavy things and it helps us and I think helps you to be in community, even if it's virtual community. Oh, I love it. I love seeing all these faces. This is wonderful. Please keep it up. We don't, and if you have to eat lunch, great. No, no, you don't have to be shy. We're human beings. I love it. Thank
There
you,
might be a cat. Is there a cat or a dog when I wander through?
everyone. Yes, totally. Um, Professor Freeman, welcome.
Well, thank you. Thank you for inviting me. I appreciate the opportunity to speak to all of you. It's a very difficult, challenging moment for lawyers and for the rule of law. And a lot of us are paying attention in a way we've never paid attention before to, on a daily basis, to what the federal government is doing. And I have to say, I've been teaching law for 30 years, and many of you are of my vintage, but many of you may be younger. And in all of my time teaching about the operation of the federal government, I mean, I obviously have a specialty in environmental regulation and climate, but I'm putting that to the side for the moment and speaking in my capacity as a scholar and a teacher of the federal government. In all of my time teaching, uh, I have never seen an effort like this to essentially dismantle the capacity of the federal government to be a source of expertise and professionalism and to convert it into a political weapon on behalf of the current occupant of the White House. And we've never seen anything like it. And it comes along with egregious violations of civil rights, as you mentioned, Venu. I'm not a civil rights lawyer, but I'm familiar enough with the framework of the Constitution to at least know that we are experiencing an unprecedented assault on due process, the First Amendment, the Fourth Amendment, and I could go on to the amendments, including the second, shockingly. And so the context now for us, for lawyers, is an unknown context. It's like a new territory that we're experiencing, that we're witnessing unfold. And my main comment to this group is just to say there's so much lawyering to do. There's such a need for lawyers at the moment to defend the rule of law, the Constitution, whatever your policy perspective is. I always say to my students, it's absolutely fair game to disagree about healthcare policy and tax policy and the role of the U.S. internationally, and we all have different views on this. And the spectrum can go from libertarianism to social democratic Zoran Mondami. I mean, these things are all fair game, but the core fundamentals of the Constitution, the structure of the Constitution, the checks and balances, the protections of the Bill of Rights, that to me is not up for grabs. And I don't feel that's a partisan thing to say. I say that to them. And so our role is crucial and our obligation is crucial at this time. And I'm just encouraging everybody in my orbit, students, colleagues, fellow lawyers, to find a way to do what they can to defend the basics of the democracy. So that's my main, that's not a surprise to anybody that a Harvard law professor would say such a thing. But as I say to my students, if we at the law schools in the country can't stand up and defend the First Amendment and due process, we ought to turn the lights out and go home. So that's my main message. I'm happy to talk about anything. I wrote a piece with Sharon Jacobs that Venu mentioned. I wrote a big article in 2021. This was after the first Trump administration, and we sort of canvassed all the ways in which a very dedicated president who was committed to sort of dismantling the administrative state, all the tools they might try to use. And then we talked about all the public law, both constitutional and statutory, that could be obstacles to that. Enhancement of executive power, dismantling the administrative state. And we ended up analyzing all of the possible obstacles and coming to the conclusion that there were so many workarounds and loopholes to statutory protections and constitutional protections that in the end, what we said was the Congress will be necessary to prevent that kind of committed dismantling. And we were both, in a way prescient. I mean, weren't that prescient. We had a first Trump administration, but we sort of cataloged all the things and we anticipated, but we were not pessimistic enough because we did not think about the Alien Enemies Act, never crossed our mind. We didn't think about the Insurrection Act, never crossed our mind. Now I have colleagues like Jack Goldsmith and others who work on foreign relations law, who work on the president's role in deploying the military, who have thought about the breadth of those statutes, but we had not included them. So our piece, structural deregulation, was on the money, but not sufficiently comprehensive to anticipate everything. So we're writing a follow-up, of course. But the conclusion largely is still going to be you need the Congress to amend statutes, to exert its own constitutional authority, and to exercise a constraint on the presidency. So none of that, again, will come as a surprise to all of you. But I'm happy to talk about. I also have a side career on LinkedIn. I don't know if anybody knows about that. And all of us feel like when we post on social media, we might be having zero effect. It might be a useless thing to do, but I've come to see it's one way to try to reach folks, and so I'm quite committed to it. So I'm happy to talk about my LinkedIn career or anything else of interest to you all. I, of course, don't operate within a law firm environment. I know it's very easy to say, oh, law professors, they can pop off and have opinions about everything, but we're running a business here, and we need to operate within certain constraints. I'm very sensitive to that. But nevertheless, even for those of you at law firms that have signed agreements with the administration, and certainly for those who have not, or those at medium and smaller size firms that have fewer of those constraints and aren't worried about regulatory retribution, for example, disapproving mergers that your clients may need. For those who are differently situated, there's always something to do. There are things to do. And so I'm a big proponent of find the way within your constraints to have whatever impact you can. So I'll leave it there, and I'm happy, Venu, to take your questions or other questions.
I have lots of questions. I'm going to try to keep them short so we can also hear from the folks who are with us about the questions they have. Just as a reminder, if you have questions, we're taking them in the Q&A. You may have to hit the more button to submit your question. Whatever questions can be answered by our team in the Q&A. They'll be typed, and then around we'll have 15 minutes where I'll go through the questions in the Q&A and ask them of Professor Freeman. Professor Freeman, I'm just going to back it up. Thank you so much for all of that wonderful information. You mentioned your LinkedIn career, which is, I've been a fan of Professor Freeman's LinkedIn career for a long time. Um, and when Professor Freeman and I talked, it was really interesting because she mentioned, look, I'm not a civil rights lawyer. And I said, well, you're an expert in agencies, and so much of civil rights is regulated, enforced, guided by agencies. Certainly at the
Mhm.
Chicago Lawyers Committee, our education practice, I mean, so much of what we do, but just like to put it in focus, our housing practice, our education practice, right? All of that is kind of the administrative state.
Right.
Um, uh, the equal employment. I mean, there's so much. And so I started following you on LinkedIn and noticed like not only you weren't just talking about climate, you were talking about abuses of power
Yeah.
across the board. Um, I am curious. Well, I let's first talk about sort of the systemic deregulation and then
Mhm.
how it led you to wanting to talk about these broader issues. Could you
Yeah.
explain actually what systemic deregulation is for folks that don't know?
So first, let me say, I mean, a lot of us have sort of specialties within our academic and government careers. You know, I've been in academia, but of course, I had a stint in government in the White House, and then I've served on, Fortune 100 boards. So I have a little bit of a sense of what business does. And at this moment, I've put aside my subspecialties, anything I care about that isn't core to defending democracy, essentially. And so that's why I'm preoccupied with the part of my work that has to do with, as you say, Venu, with federal agencies, because in every one of the examples we can think of right now, where we see an abridgment of rights, where we see the federal government engaged in overreach, stretching statutory authority, testing constitutional limits, daring the courts, trying to outrun the law and make the law catch up. In every one of those examples that we've been living through for at least this past year, there's an agency operating the tools of the state. There's the Department of Homeland Security and its subcomponents, the Border Patrol and ICE. There's the Department of Justice itself, which has been turned into a prosecutorial arm of a vengeful president. And so you can't look and see legal violations without seeing agencies executing them. And that's what's so, I mean, it's the wrong word to use, but it's both alarming, but it's also interesting from a legal analytic point of view. How is it happening? What are the tools that are being used? How are these statutory authorities being either ignored or stretched and deployed? There are many legal arguments here at play where we have to come back and say that's not how the law works. That's the wrong way to interpret the law. That's contrary both to
Yeah.
clear statutory meaning or at least historical practice and policy. That's not the internal policy of this agency traditionally. You're violating the internal policy. So when I talk about structural or systemic deregulation, what I'm talking about is a combination of steps that an administration can take to move aside the experts in these agencies who have mostly the career civil service, professional public servants who are committed to operating the law in a nonpartisan way. And they serve whatever administration, of course, has the controls at the moment. But they have never been turned into a political partisan arm of the administration before in this manner. And so the steps towards structural deregulation have to do with de-experting, to make up a word, decompetencing the government, which has to do with really boring things like ignoring civil service protections and firing people so that you can put new people in their place. Well, there are statutes in the way of that. There are many procedural fouls that have been committed that you can sue about that say you can't remove a bunch of civil servants and put in place a bunch of loyalists. You violated the law in these various ways and so on. So these things are quite core and quite invisible to the operation, the daily operation of agencies, but it's really important to defend the set of laws that have been put in place to prevent the government from simply being an arm, a political arm of the administration. And we've created a professional civil service that's designed itself to be a constraint on the abuse of power. And if you dismantle that professionalism, you can see this happening at the FBI, throughout the Department of Justice with the replacement of prosecutors, the mass resignations of professional civil servants who served in these prosecutorial and investigatory roles, the removal of expert advisors from agencies like the Department of Health Department, the removal of expert advisors from environmental agencies, the removal of experts, the dismantling of the Department of Education, the dismantling of USAID. You know it all. You've seen it all unfold. But everywhere you look, there is an agency that has competence, that has professionals within it who are under attack. And that's a sort of part of a strategy. And it was outlined in Project 2025, so we knew it was coming. But that is part of a project to own the government, to turn the government into a political apparatus primarily. And then it's now being used to deprive people of their rights on a systematic basis. And again, everywhere you look, there is an agency that has to accomplish this. Executive orders, by and large, are not, except in the realm of foreign policy typically, but even there, they're not self-executing. I teach executive orders as press releases or as directions to other parts of the government. You need the government to then operationalize those orders. And that's what you see when you see DHS essentially. So it's a very long way of saying structural or systemic deregulation is just a term that refers to really coring out the capacity of the federal government to be used as statutes require it to be used, as Congress requires it to be used, and the Constitution requires it to be used as a political arm for the occupant of the White House.
So you said so much.
I know, sorry, long
No, it's
answer.
so
People
your
now left to
brilliance
eat
is
lunch.
obvious.
People
Um,
are all,
so so what I hear you saying is that in order for, because executive orders are, let's use your language, sort of essentially a press release, that the only way for an executive order to be operationalized is if the agency itself or the people within the agency have loyalty to the executive order. Is
well,
that
well,
correct?
what I would say is executive orders all have at the end of them, to the extent permitted by law. There's a boilerplate catchphrase at the end, as many of you know who've dealt with them and who've read them or written them. They have a boilerplate to the extent permitted by law. So there's already acknowledged within every presidential executive order the fact that there may be a statutory or constitutional limitation on whatever that executive order says should be done. And all I'm suggesting is agencies know they're bound by statute and bound by the Constitution. And they even know that the executive orders contain an acknowledgement of that. And so if you're going to blow past statutory and constitutional constraints, you're only going to do it if you're prepared to play a role that it violates the oath you've taken as a member of the federal government, certainly, if you're an official in the government. So my only point is just to say the only way you can accomplish substantial lawlessness across the federal government is if you have in place a set of loyalists who are prepared to ignore statutory law, the Constitution, and internal policy and practice, right? And you can only accomplish it if you're prepared to clear out the lawyers who typically say, not necessarily no, because government lawyers don't often say no, but they often create sort of process that slows down decision making, and they require a ventilation of alternatives. And if you clear out those lawyers, whether you bypass the Office of Legal Counsel at Department of Justice, which is happening, or you fire the military judge advocates general, or you fire internal lawyers who otherwise create roadblocks and speed bumps and process, then what you're doing structurally is creating lawlessness internally so that you can conduct lawlessness externally. And that's really what I think has unfolded over the last year.
That's what you're saying is really powerful. I mean, I think even as folks who work in the civil rights arena, to to think about the lawlessness internally like is a really visceral image. Um, so you and I, when we talked a little bit before talking here today, I said I don't think that folks, and potentially myself included, depending on the scenario, like really understand the connection between having robust agencies and democracy. And maybe not understand is not the right word, but like have it top of mind. Like they're not thinking about how important it is to have a robust HUD
Yeah,
and democracy. And I actually, I said to Professor Freeman, I said, we know the damage that Doge has done. And I have friends and family who were like, yeah, but the government could
right.
use some efficiency, right?
Yes.
So I would love for you to both connect those dots explicitly and then yeah,
Yep.
that would be great.
What I always say in response to a question around, shouldn't we be shaking up the federal government? What's wrong with what Doge tried to do is I am the first person to sign up for government reform. Sign me up. I worked in the federal government. I worked in the White House. I tried to corral agencies to do things. It's intensely frustrating. There are lots of coordination problems. There's plenty of over bureaucratization and red tape. But here's what I'm not for: a completely strategy free, indiscriminate, vindictive approach to just fire a bunch of civil servants who turn out to have essential knowledge, essential expertise to deliver the things that the American public needs. We need experts in disease control. We need experts in keeping the nuclear arsenal safe. We need experts in making sure that trains don't derail and planes land. We need experts to conduct diplomacy with a historical institutional knowledge of how one conducts diplomacy and with expertise. It's impossible to run a modern society and economy in a manner that will deliver benefits to the American people without experts. So I'm not going to defend the status quo,
Mhm.
because those of you who know HUD better than me, and those of you who know the Department of Education and the Equal Employment Opportunity Commission and the Department of Labor, those of you who know all these agencies and the FDA better than me will say, let me tell you, I've been frustrated all my life working with these agencies, and I have nothing but empathy and sympathy for the idea that we could conduct very meaningful government reform. But what Doge was up to was not that. And we saw terrible mistake after terrible mistake. They had to hire back a bunch of folks that obviously were core to the mission of these agencies over and over again. There was no strategic plan that would actually be beneficial over time. So I think recognizing that we need a competent federal government in order to conduct business right, in order to have a thriving economy, in order to ensure that capitalism works well. Indiscriminate, unconstrained capitalism is not, I would suggest no constraints on the market is not a society or economy that benefits the majority of Americans. Capitalism with constraints, right? Some appropriate regulation, we can fight about what's appropriate. But what I'm not in favor of, and what I think we witnessed, certainly Doge began it, and it's been continued to a significant extent even after Elon Musk left the scene. What we don't want is a fundamental decompetencing of the federal government, so it cannot be a meaningful partner in delivering on the statutes that Congress has passed that provide us health protection, environmental protection, civil rights protections, and so on. We're entitled to see those statutes implemented, and we can't have the benefits of the United States Code unless we have experts in the federal government to work with. That's my pitch to you, not that we shouldn't be reforming the government.
Um, I think you're
Oh,
you're
and
with your people.
the last thing I want to say to you all is you see what happens when expert prosecutors who have a commitment to the rule of law, who are civil servants, who are there throughout the switch of administrations, but who have a view of themselves as professional prosecutors, or in the FBI, professional investigators. And these are not liberal progressive people. By and large, these are conservative people. You know, the FBI is thought of as the cops, right? I mean, these are not woke ideologues. But when you see that they are either fired en masse or reassigned en masse or intimidated or threatened with being fired if they don't toe the line, and they resign, conservative Republicans resigning one after the other, something is wrong
Yeah.
with the federal government.
Thank you. I just I want to, because I'm curious myself and want it to be explicit. I you have so much that I want to follow up on, but what is it about, what is the link, like, so you're saying it's important to have robust agencies because they help us function, that they are critical to a democracy because they allow a version of constrained capitalism, expertise, all of these things to um, to actually get done day to day to day. Is there
Somebody
anything?
just popped up in the chat with the weather forecasts are off. I don't know that that's true, but if that's true, that's disastrous. I
Yeah,
mean, if you're engaged in preparing for a terrible hurricane or flood or the storm we just experienced in much of the country, and you can't rely on government forecasting, I mean, that was a great little point in the chat. Look at the risks. Look at the risks that are created unnecessarily. If you have an immunization program that's being fundamentally overturned, that has served to protect American children for decades, and there's literally no evidentiary change that would justify a change in policy around immunization, you're putting kids at risk. So all I'm suggesting is if you replace expertise with politics,
yeah.
it's going to be much harder to get the benefits of all of the statutes that in theory have been passed over the variety of decades that are meant to deliver us these health and welfare benefits and to ensure we can be a thriving society and economy. I mean, the government, you know, a lot of people are frustrated with the government and want it to be more helpful to all of us. But now it's being put in our way, right? It's now against public health protection. It's against neutral prosecutorial policy. It's again, you know, this is a sea change that doesn't benefit anybody and is going to hurt a lot of people.
Thank you. So let's talk about HUD specifically, because at least at the Chicago Lawyers Committee, it is something that has been a very personal struggle for our organization and the work that we do, and not about the specifics of HUD, because I know that that's sort of
Not a HUD gal.
you're
Yeah.
you're not a HUD gal. Um, yeah, and so, but one of the things that I think we get wide-eyed and frustrated and angry about is exactly what you're saying, is that, right, just in the specific example of HUD has been, not only is it not a neutral entity not helping, but it's now being weaponized, right? These agencies are now being weaponized. And in your writing, you talk about how it's really challenging because litigation is not a great, um, at least that's my understanding of it, that
Yeah.
litigation is not a great tool at trying to like get
Yeah.
agencies to act as if they should.
So I've never, you know, I'm not a litigator myself, although I've certainly participated in or advised on litigation, but I've never been the law professor who says litigation's the answer to everything. I'm the law professor who says, you know, mediation, coordination, you work things out, you settle matters. And so I'm now completely transformed. And if, you know, my basic, my basic advice at the moment is sue their pants off. I mean, I think law and litigation right now has to be deployed really aggressively and assertively to beat back the abuse of law by the government itself. So that's the position right now I'm in, and I don't think it's you know, litigation is not the long-term solution to the problems of our society, and rarely is. But at this moment, when the government is actually being deployed in such a lawless manner, you need to push back with law. That's my point. And I think that's true. That would be true if HUD were if HUD is violating statutes, violating the Constitution, or violating internal policy. I think they need to be held to account. if there's no accountability, we're going to have a problem. There can be no rule of law without accountability, right? Accountability is central to democracy. You know this. You don't need me to tell you this. And if there's no accountability, um, we can't expect the government to deliver on what the statutes that they operate under promise us. So that's my main point. And from a constitutional perspective, if we don't defend the First Amendment, due process, the Fourth Amendment, and so on, then the only people using the law are going to be the people violating it, and that's a problem. You need to fight in the federal courts at the moment is my main argument, and that's litigation. Litigators are critical.
So on that point, I think many of us here would agree with that. With respect to agencies, what are the opportunities and constraints? Like you said, right, it can't be a long-term solution, particularly, or even a medium term with this Supreme Court potentially. So where do you see like the best opportunities for holding agencies accountable through litigation? And where do you feel like the constraints are?
Well, first of all, there's a transformation of some parts of traditional administrative law that are likely to take hold that we're not going to stop. I think Supreme Court is poised probably to allow presidents to fire heads of independent agencies summarily without cause. And I think that's an extension of a series of cases the Supreme Court has decided, including Saylor Law and others. And it's given a lot of hints in the emergency docket recently that the independent agency structure is probably going to be ruled finally after 90 years unconstitutional. So I think we're going to have to accept probably that that is a new status quo, a new reality. And I think the expectation is they will carve out the Fed somehow by reasoning that it's somehow different historically and preserve the independence of the Fed. That's reading the tea leaves of what the court has said on the emergency docket in the past year or so. So there are some structural changes that are very likely to happen, and the Supreme Court has, over the last several years, been transforming the administrative state in fundamental ways. The major questions doctrine that the court has announced and embraced, which says basically agencies can't do big things with their statutes, ambitious things, reading statutory language to address new problems, unless they have explicit congressional authority, explicit text to point to. That is serving as a constraint on agencies using older statutes to deal with newer problems by reading broad delegations in a way that encompasses new regulation. So the court has already moved to constrain what agencies can do through the use of the major questions doctrine and other tools. And now it's enhancing the powers of the president to control agency heads by firing them at will. There are certain of these structural features, I think, that are now just going to be baked in and be part of the status quo. But setting that aside, the day-to-day work of agencies still has to comply with quaint statutes like the Administrative Procedure Act, which I know bore you to tears and drive everybody to just turn the camera off and go get a snack. But the APA is my bread and butter. And we hold agencies to account when they circumvent the Administrative Procedure Act, when they don't play by the rules, when they skip regular order. Judges, both Democratic appointees and Republican appointees to the bench historically, they don't like it when the government cuts corners and commits blatant procedural fouls and just says, we don't have to go through notice and comment. We'll just cite good cause and skip it. And we'll rescind all these rules. Judges, whatever their political nomination history, tend to not allow for that kind of blatant illegality. So my view is you hold agencies to account. And remember what I said, there are agencies conducting everything now that you see playing out, including what's happening with DHS, with ICE and Border Patrol. There are agencies taking steps that either violate statute, violate internal procedure, violate statutes like the Administrative Procedure Act, or violate the Constitution. There are avenues to hold them to account. And some of them are the civil service laws, boring also, right? I teach a bunch of super boring stuff. How about this statute, the Federal Advisory Committee Act? Ever heard of that? The administration, in putting together a task force with hand-selected, now I'll bring climate change in for 30 seconds. They hand-selected the Department of Energy, a task force of climate skeptics whose published work is known for denying the consensus on climate change. And they handpicked those experts and put them on a task force to write up a report that said there's really no really big risks because of climate change. It's all been overstated and the science is wrong. And that violated the Federal Advisory Committee Act, and a federal judge said it did. And so that report now really should not be relied upon by the Environmental Protection Agency when it rescinds its climate rules. And if you knock out the claims, the untruths, the procedural violations, the legal violations, if you keep at it, if you keep chipping away, you knock out that foundation they rely on for their agency actions. And it becomes very difficult for federal judges not to see what's going on. And so that's why I say you'd use all the boring statutes you've ever heard of to hold the agencies to account.
Um, wow.
Yeah.
So, yeah, so I think this is a really great segue into what lawyers and non-lawyers might be able to do for whoever's here. I just, I'm wondering, is there an effort, and there's lots of efforts right now to uh, protect the democracy that is in peril, but is there an effort to watch? Is there like an agency watch list somewhere
Yeah.
or for lawyers to say like, hey, I'll leave it to you to answer
Well,
that.
there are lots of organizations that are tracking all the administration's actions. I don't know of a single hub that's tracking every agency at once, although you can piece it together by going to various websites. You know, from the Brennan Center to Democracy Forward to Lawfare's website. There's a variety of locations where you can go, and depending on what you're interested in, you can see sort of all the civil rights cases that have been filed, or all the cases suing for illegally firing civil servants or prosecutors or other members of the federal career staff. You can go to websites and find all the deregulatory steps the agencies are taking in one field or another. So there is a tracking going on. And for lawyers in particular, you know, there are a lot of organizations like your own that are hubs of activity where lawyers have committed to some pro bono hours or some amount of reduced fee time to help in supporting lawsuits to fight back. And that's where I think you can really make a difference. And, you know, again, I mean, I'm sensitive to the fact that there are certain law firms that have signed agreements with the administration. I have views on that. I don't know that this is the forum to offer my views on that. But if you operate in those firms in constraints like that, where your pro bono programs have a commitment now to serve some of the administration's chosen um, uh, projects, there may still be room to do some pro bono work, either that doesn't conflict. If you run conflicts and you get the approval of the firm, there may be some flexibility at some firms to still do some pro bono work in your personal capacity, where there may not be a conflict. I think that's possible. There may be firms that haven't signed agreements where their pro bono programs are still looking for work to do, and you can participate in civil rights protection work. You can participate in individual immigration cases. You can participate in election litigation that is going to be very critical around the midterms and going forward. And then there are firms, you know, I'm sure there are mid-sized and smaller firms that don't have maybe organized kind of pro bono offices, but where individual lawyers can decide what they want to work on and can make commitments of time or offer reduced fees for certain work. I think there are lots of opportunities to decide what you want to work on. And of course, you can do this behind the scenes too. I've heard that there are plenty of lawyers at the big firms, you know, the top 100 or whatever, and the ones that signed agreements with the administration. There's still plenty of lawyers who behind the scenes are doing some advising on litigation. Their names aren't attached to it. It's not public, but they're still making themselves useful. And you can even advise legal clinics at law schools to some extent if you want to provide help for certain academic centers. I think there's no shortage of opportunity. You have to find them, you have to organize, you have to connect to them. But I think whatever context you're in, there's got to be some flexibility to find ways to deploy your time, even if it has to be your personal time. Not that you have much personal time if you're working in a law firm. The other thing I would just say is, you know, the situation we're in right now is very much in flux. in the sense that things may get better in the sense that law firms, even those that signed agreements, they've signed agreements under conditions that are clearly unlawful and unconstitutional. I mean, we have a series of decisions from the appellate courts that say the executive order attacking law firms that provided the cover to extract these agreements are unconstitutional, patently. There is no decision from a court of appeals that says that they're lawful. So the agreements have been signed notwithstanding the fact that what the federal government is doing is illegal. And so two things might happen. One is it might get better in the sense that law firms that signed agreements might soften a bit on whether they're prepared to back away from them and whether they're prepared to recommit pro bono work more publicly to work that may be seen as counter the administration, and they may become braver. Maybe firms, of course, where we don't see the deals, the regulatory deals that need approval, may be the first to do that. So things could change in the direction of feeling more emboldened. But the other thing could happen is it could get much worse. And if it gets, this is a point that a friend of mine, Scott Cummings, who's a UCLA professor and an expert on the legal profession and professional ethics, and who is writing a lot now about democratic backsliding. Scott Cummings said to me the other day, it's not just that it could get better, it could get worse, in the sense that things could become so bad along the lines of more people being shot in the streets, more citizens being, or residents being shot in the streets in a clearly unlawful manner, things escalating, that law firms just decide, we can't maintain our posture. We must now be part of fighting back against lawlessness. So all I'm suggesting is things are fluid, and you need to be ready to seize the opportunity to deploy your legal skills if things get better and if things get worse. And if either of those things happens, there may be opportunities to do more work.
Professor Freeman, thank you. And we at the Chicago Lawyers Committee are ready and lucky to have member firms, and we're ready to work with any firm at any time when they're ready to defend civil rights and democracy and the rule of law. Thank you for that. It was very powerful. Let's go to, there are a couple of questions in the chat, so I want to answer those. Kelly, I see your question. We had a couple before, but I will we'll get to yours as soon as I ask these other two. So the first question, Professor Freeman, is let's assume a new administration comes into power that wants to restore an administrative agency apparatus that is not led and populated by political actors. Can that be done without turning the entire structure into one that gets purged every 4 years?
Yeah, this is a really good but hard question. I mean, of course, there's an appropriate role for political appointees at the top of all the agencies. We have a system historically where we have a layer of political appointees. It's not that agencies don't pay any attention to the prerogatives of their administration. There are always a layer of folks who are trying to drive forward an agenda. The problem is if you core out all the professionals beneath them who have the expertise and institutional knowledge to last administration to administration. So I would say restoration, I don't think, will ever involve purging all political appointees, but rather restoring a balance. And that's going to be very hard, and there will be hard choices for a new administration, whether Republican or Democrat, that wants to restore the credibility and the expertise of the federal government. It's going to be very hard because the temptation, I think, might be to not want to appear to be partisan and therefore to leave in place all the folks that are there. I personally think that would be a mistake. But the other risk is looking like you're purging every 4 years. And it's going to be very hard. I don't think this is a project for 4 years. I think this is a project now for decades. That is to restore the expertise and credibility of the federal agency apparatus. I'm particularly concerned about a couple agencies that I don't normally focus on so much, but the Department of Justice is number one. You must restore the credibility of the prosecutors and the investigators and the law enforcers and DHS, whose credibility now is, deeply undermined, if not destroyed. People now fear, right? Now fear Border Patrol and Immigration and Customs Enforcement regular citizens now fear law enforcement in a way that they haven't historically. Now, there's obviously always been some fear of law enforcement, certainly in local policing, certainly appropriately so. We have a long history of abuse, but not at this level for federal law enforcement, right? So I think that the restoration of credibility is going to take some very hard decisions, which will involve firing some of the people who clearly broke the law. I think there will need to be accountability, meaning investigations, and in some context, prosecution for people who've broken the law. And then a very public commitment for the new administration, again, whether it's Republican or Democrat or something else, a very public commitment to ethics, strict adherence and restoration of ethics rules, strict adherence to professional norms. And that's going to have to be communicated over and over, demonstrated over and over. This is like coming back after the Nixon administration, for those of you who are old enough to recall sort of the set of reforms after Watergate. This is going to make that look like child's play. We're going to need new statutes that constrain, the lawlessness we've seen. And it will be hard not to overdo it. The risk will also be overdoing it, because I'm not suggesting that the president shouldn't be powerful. I'm suggesting that there needs to be a balance of authority. So I think it's going to take some firing, some accountability, some recommitment of ethics, some new statutory constraints, and it's going to be a long-term project, which I hope you'll want to be part of. I mean, I want to be part of it. I want my students to be part of it. It's an opportunity to rebuild, and not to rebuild what was there before, but something better, and to improve government and make it more efficient and make it more responsive and modernize its technology and so on.
We had a mayor in Chicago who became quite notable, Rahm Emanuel, who
My
said,
old boss,
"Oh yeah,
he was my chief of staff in Obama days. I loved
oh
Rahm
my
Emanuel.
God."
He was like, points on the board, people, put points on the board.
People have mixed feelings in
Yes, I'm sure. I'm
Chicago.
sure. I'm sure. I know. I
Um,
know.
but I will say, one of the things that he said was never waste a good crisis. And
Absolutely.
we are absolutely in a crisis. And something that we talk about at the Lawyers Committee a lot is, what are we going to build that's better?
Yeah.
Because the rebuild time will come. Who knows when, but it will come. And
Yeah.
we're not at a U-turn. We're not at the like we can make a U-turn. Now it's like right, because so many things have been broken. Like what are we're going to go through, and we're going to have to build it better.
Yeah, that's true. And I think the work has to start now, including, there are folks working on legislation. What would legislation look like? Even though we think, well, Congress won't ever pass anything, that's not so. There will be a windows of opportunity. There
Yep.
will be a time again when we'll see legislation, not just budget reconciliation, but real legislation, that's more durable than budget reconciliation, that can be undone very easily. And the question is, will you be ready with proposals and improvements so that when the door opens, you're ready for those to be adopted both at the state level, at the federal level, and so on. But right now, the work is really specific and in the trenches of defending the legal order. I mean, that it's as
Yeah.
stark and as simple as that. The fundamentals. People should not be shot in the face or shot in the back when they are lawfully protesting. Okay, this is unacceptable in a democracy, by masked, unnamed individuals carrying weapons, carrying out indiscriminate raids. This is stuff of an authoritarian regime of other countries that we used to think, well, that can't happen here. It's happening here. People who aren't awake need to wake up, and there's never been a more important time for lawyers to defend the rule of law. Again, I don't think we have to agree on policy. I'm happy for people to completely disagree with me on my policy and politics, but this stuff you have to fight for.
Um, Thank you. There's another question, which is what has been revealed with the Trump administration is that much of what we counted on to protect us was not in the Constitution or statutes, but merely norms. If the opportunity, if the opportunity ever presents itself, do we need to give these norms the force of law? So similar.
Yeah, I mean, I do think we can encapsulate some norms into law. I think that we could draft ethics norms into statute, for example. I think We could tighten up, as my colleague Jack Goldsmith has very clearly articulated, we could tighten up statutes like the Alien Enemies Act and the Insurrection Act to create more procedural constraints around a president so that there must be more consultation with Congress and more reporting and time limitations and so on, so that the broadest powers that we thought would be constrained by norms will now be constrained by procedure and requirements and real statutory limits. I think converting what we thought were norms of prudence and self-restraint that we've relied on for decades, if not centuries, we can no longer rely on. We've seen that's true. So yes, I think we can incorporate some of those things we used to think of as unimaginably not, this is not necessary. No president would do this. I think we have to now think about encapsulating in law. But at the same time, we have to just reinstate the norms. We have to behave. I mean, I don't want to be on a big soapbox exactly because you all know this, but the president needs to behave with dignity and humanity. The president needs to not sow division. And so that's about character and that's about norms. That's about who you put in office. And so some of that, you can't legalize character and you
Mm.
can't require people to behave in a dignified, respectful manner. So I'm not sure that we can put everything into law, but there's certainly things we can capture in law, and we need to think about and do that hard work. That's really hard lawyering work, right? How do you amend this statute? What exactly needs to be done? How do you make these commitments binding? That's hard lawyering work.
Thank you. Um, I would argue that I think impeachment is supposed to do some of that, but we're
It,
not
it, what we've
we're
learned,
not
what we've
there
learned, what
apparently.
we've learned, what we've been shocked by, and I think it took us a while. It took us a few months, right? We've been shocked by the fragility of the
Yeah.
system.
Yes.
And what I say about that to my students, and whenever I talk about this, is, law is not a sure thing. Law can be used for terrible purposes. We all know instances in history where law becomes the cover for, really dangerous action by a government. Law can be used strategically as a rationale to do lots of terrible things, but law can also be used for glorious things, right? And the question is, who's fighting in the terrain of deciding how the law will be deployed? And you have to be in that fight, but there's no guarantee. That's why what's happening across the country. I was in Los Angeles for the deployment of the Marines and the Guard in Los Angeles. And now we're witnessing it unfold across all the other cities from Chicago to Minnesota. And what's so astonishing to me is the bravery of people to come out and protest and to hold up their phones and say, we're going to witness, we're going to document, then we're going to swear declarations so that they become part of the legal record in a federal lawsuit where a judge has to preside and the government has to show up and answer.
Yes.
And that's really important, even if you lose.
Professor Freeman, you've frozen. I will just add to that until you come back to us. If somebody from the CLC team could let Professor Freeman know that she's frozen. Um, I think this is something bearing witness, observing takes tremendous
Am I
courage.
back?
You are back. I'll just
Okay.
finish my sentence. And this is something that lawyers and non-lawyers can do.
Yeah. I just think that the power of being part of the record keeping and the witnessing and the helping hold account is critical. And my point earlier was even if you lose, I mean, even if qualified immunity is an incredibly difficult hurdle to clear, even if Bivens, and you know more about this than me, I'm just an observer of civil rights litigation, but even if Bivens is so highly constrained, even if, right, it turns out that while the vice president said there's absolute immunity, he was actually technically and formally wrong. But in practice, it might turn out that there is virtually unlimited flexibility for federal agents to do what they want to do, and including violate your constitutional rights. Even if it turns out to be true, you have to fight and fight and fight to hold to account. And I think creating these records is really important. It's very hard if you put this in front of a federal judge, for that federal judge not to think something is terribly wrong here in the application of the law.
I've Kelly has been very patient, and I just want to. I think it touches on something. She put a question in the chat, or he, or they. Is there a place for protest? Not the kind of protest we're currently seeing, but the protests that call for due process, rule of law, respect for the Constitution, administrative independence, etc. Stuff that people on both sides of the aisle can get behind.
Um, I, so what do you mean? Just lawyers protesting or
I think what Kelly is trying to ask is like we see protests around. I mean, courageous protests around fighting against ICE, like
yeah.
courageous protests around like the Trump administration itself. I think what Kelly's asking is um, where is the protest, or do you see in your purview a protest for actually these the
These
mechanics?
things we care about. Yeah, I think the best, this is just my point of view, and we all have different points of view. This is now not so much a law professor expertise thing, but just a human point of view. I think the best thing we can do now is the seed work to defend the integrity of the election.
Mhm.
And rather than, I mean, I think people should mobilize. I think the No Kings protests were an important vehicle and they may happen again. I think what the Minnesotans are doing in their home communities, what LA did in its home community is important. Nonviolent, 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 of course. But I think that's very important. But I think in terms of mobilizing and focusing your energy, I think making sure that we will have free and fair and meaningful elections, that people will not be intimidated from voting, that people will not be prevented from voting, that we have a plan in place if there are abuses of power during the election, if federal agents are deployed to the streets and so on. That's what I'm worried about. And so if you're looking for protest, I would channel it into defense around elections because that's where all the marbles are.
Yep. I'll just add that Chicago Lawyers Committee, one of our really critical pieces of work is around voting rights. And we are preparing to do election protection work and have litigation going in Indiana and in Illinois and Indiana to protect naturalized citizens, which is sort of the parallel fight against the ruse of immigration or undocumented folks. Um, so I appreciate that, Professor Freeman. And I'll just mention again, if you would like to support the Chicago Lawyers Committee in this work, currently we have a group of supporters who is matching every dollar that is given up to 50,000. Please consider making a contribution. CLC is the premier voting rights legal advocacy organization in the state, and we can't do it without you. Professor Freeman, we have 1 minute left. Is there anything that you'd like to leave what I think is a group of folks who are probably all on the same page and wanting to watching what's happening and wanting to know what they can do to make it stop?
Yeah, I would just say I've never been prouder to be a lawyer, and I've never thought that lawyers were more important. And I just would be proud of what you do. And I know we have day jobs and we have to, whatever firm we're at or whatever, I'm in academia, we have to, do our work and but there's other time that we can use even if we can't within the constraints of the firm do things. There's other ways to use your skills to participate in the defense of democracy and the rule of law, and I really want to insist that this is not a partisan exercise, and I hope you will do the same. This is for anybody who believes in our constitutional system, and I think we should talk about it that way. There will be lots of time to disagree about the priorities of the society, but all of us should be in for the defense of the rule of law. And that's what I'm excited about. And I hope you will also be excited about that. There's a lot of opportunity. There's no shortage of opportunities. And I hope you'll feel like you can do something.
Professor Freeman, thank you so much for your time and your willingness to talk with us. You sound like a civil rights lawyer to me.
Thank you.
Yeah, and wow, look at all the hand clapping
Wow, thank
giving.
you.
Yeah.
I didn't know you even could do that on Zoom.
You
Thank you for having me. Very, very kind of you. And I wish you all good luck and toast to democracy in our way of life if I had a
Yes.
drink.
Yeah. Next time we'll do it over drinks.
Okay.
All right. Thank you,
Thank you.
Professor
Thanks
Freeman.
very much.
Bye.